Like you can't remember my name, I don't remember.
Okay, so the answer is I don't remember. No comment.
We've all seen cops overestimate their power, but some take it way too far. And in today's case, these officers walked into court thinking they were untouchable, but the consequences were deadly.
Verdict reads, we the jury, having found the defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter.
Officer Devers' time at the Canton Police Department takes a sharp and unexpected twist. Her testimony shifts without warning, and her false memory claim turns an already sensitive case into something far more unsettling.
Officer Dever, did you go on to say in that interview, quote, you never saw them leave, them being Brian Higgins and Chief Ken Berkowitz. You never saw them leave, but you recalled thinking to yourself that they were in the Sallyport for a wildly long time together in there, end quote. Did you say that?
That was my recollection of the time.
Okay.
So yes.
You indicated under questioning by Mr. Brennan that you knew what they wanted from me, meaning the defense, what they wanted from me.
Yes.
You saying that?
Yes.
You remember on that phone call that we read directly from the exact same report that I just read from? You remember that?
And I told you the same thing then.
That's not
yes.
a question.
Objection.
Sustained.
My question is, just answer my question, Officer Dever. Did we read to you, were you read the exact same thing that I just read to you on that phone call?
Like you can't remember my name, I don't remember.
I can remember your name, Miss Dever.
Okay, so the answer is I don't remember. No
The answer is a
comment.
little more than that, Judge. I think we all.
All right, so
I'll
no
ask
no
you a question.
comments, just questions, please.
Her behavior on the stand is shockingly unprofessional, raising serious concerns about how she carries herself on duty.
Do you recall us telling you that we were looking for the truth about your
Objection.
comments?
I'm going to allow it.
That we were looking for the truth?
Which I gave you, yes.
Did you also say on that phone call something to the effect of, I know you're going to tear me a new one because I'm changing my testimony?
Changing, no. But you're trying to do that.
Did you say, I know you're going to tear me a new one?
It's what you're trying to do, so yes.
Actually, what you said was, you're going to tear me a new asshole, didn't you?
I don't recall that, so that's putting words in my mouth.
I'm asking you if you remember saying that during that phone call. Oh,
I don't
I know
recall.
you're going to tear me a new asshole.
I don't recall.
Okay. But you do remember saying something to the effect of, I know you're going to tear me a new one, right?
Yes.
Okay. Have you ever heard of something called the blue wall of silence?
Objection.
Sustained.
Do you think it's important for police officers to protect one another in the field and out?
Objection.
Sustained.
Have you spoken with anyone, not Mr. Brennan, he's covered that, you spoken with anyone from the district attorney's office about your involvement in this case? Ever?
No.
Never?
Unless you're going to provide a person. I've never talked to any of these people.
Have you talked to anyone at the DA's office at all, in any regard?
Not to my recollection.
How about indirectly?
Not to my knowledge. Other people who's been on the witness stand, one person, yes.
Who's that?
Sarah Levinson.
How long have you known Sarah?
We became friends in middle school.
Did you watch any of the trial, this trial?
Clips in passing, but no, it's 6 hours a day. So I work during the day shift, no.
So you've seen some of the footage of the goings-on in this case, correct?
Yes, nothing with her. I did not watch her testimony.
Were you aware there was a sequestration order?
I don't know what that means, so no.
You're a sworn peace officer, you don't know what sequestration means?
No.
With no proof, no report, and no real answers, her petulant behavior becomes impossible to ignore. It's the kind of conduct that hints at a deeper infection within the department.
I'm watching the proceedings in order to affect their testimony?
No, I wasn't aware.
But you did tune in to the case, correct?
In small clips, yes.
And you did, in fact, on August 9th, 2023, have a fulsome conversation with two sworn police officers about your memory of what you saw, your observations on January 29th, 2022, correct?
I don't know if they're police officers necessarily, but yes.
Law enforcement agents, how about that?
Yes.
Were you subpoenaed by the Commonwealth in this case?
No.
You were subpoenaed by the defense.
Yes.
Did they tell you that there was a sequestration order or that you shouldn't watch any of the footage? Did they fairly inform you about what the ground rules were?
No, and I wasn't part of the first trial, so I had no idea about anything to do with this trial.
When you spoke to those law enforcement officers back in 2023, do you know that they made a report where you had informed them that you knew Sarah Levinson, and that report had been provided to the defense a long time ago? Did you know that?
Yes, I informed them very clearly.
So the question about if you know Sarah Levinson, that's no secret in your world, is it?
In that form, I'll sustain it.
That isn't a secret, is it?
Not at all.
That's something you were open and candid about?
Yes.
You understand that regardless of what you say, it doesn't matter as long as it's the truth. Do you understand that?
Yes.
The Commonwealth in no way is asking you to accommodate it or please it in any way. Do you understand that?
Yes.
If there was something that may be perceived by others as adverse to the Commonwealth, you understand we would want you to tell that if it was the truth, don't you?
Sustained.
The Commonwealth has never intimated, suggested, or advised you to say anything other than the truth, have they?
No.
Have you been given any consideration or reward because you remedied your memory?
No.
After being shown the evidence that you left that day, January 29, 2022 at 3:45, and learning that the defendant's car did not get to the Sallyport at 5:30 or so p.m., is there any way you could have seen Mr. Berkowitz and Mr. Higgins in the Sallyport with the defendant's car that night before you left for work?
There is no way.
Watching an officer unravel like this in open court is a painful reminder that the uniform alone doesn't guarantee integrity.
Understanding you made a mistake, was the defense receptive to your explanation that you made a mistake?
Objection.
Sustained in that form.
Did the defense pressure you when you told them you were going to come into this court and tell the truth about your mistake?
Objection.
No, allow it.
Can you rephrase it?
Yes. When you told the defense you had made a mistake about your memory, did they pressure you?
Yes.
Did they pressure you to say something other than the truth?
Yes, they wanted me to repeat a lie at that point, given it would have been with malicious intent to repeat it.
Understanding a lawyer has no power to charge with contempt, does that change the reality of whether or not you were threatened? Let me ask it a different way. You were asked questions about whether or not you knew who could take out charges for a crime. Yes?
Yes.
Okay. Regardless of whether an attorney has that power, were you threatened that there would be a charge of perjury if you didn't comply with the defense wishes in this case?
Yes.
And knowing you were going to come into court, given this experience you had with the defense, is that why you felt like they were going to tear you? Is that the phrase we used?
Yes, because they did not want me to tell the truth. So I told them that knowing they were kind of trying to eat me alive into repeating something that is not the truth.
Rather than to come in here and be attacked, wouldn't it have been easier just to said what you had earlier thought was true?
Objection.
I'm going to allow that.
Wouldn't it be easier just to come in and accommodate them rather than be threatened?
Well, of course.
So why did you come in here?
My entire job revolves around what I say on the stand right now. If I was to lie, I lose my job. I lose everything.
When she claimed her entire career was at risk, it became clear why the truth never showed up and why perjury didn't seem to bother her in the slightest.
I'm here to tell the truth. I cannot lie while sitting on this stand.
Thank you.
All right,
one question.
Okay?
Your entire job revolves around what you say on the witness stand. Is that what you just testified to?
Yes.
And if you agreed that what you said to those two law enforcement agents on August 9th, 2023, you would be implicating not one, but two police officers, law enforcement officers. If
So-
you agreed with what you said in August of 2023 on this witness stand, you would be implicating two officers, fellow officers, correct?
So I'm confused as to what you're asking.
You would be implicating, if you agreed with me, you have not agreed that that was the truth. You've now indicated that what you told to law enforcement agents in August of 2023 was a lie.
No,
If you agreed with that statement here on the witness stand, you would be implicating two officers as having been in the Sally Port, weirdly, for a wildly long time with the SUV, implicating not one, but two fellow officers, correct? That's what you would be doing.
it's not possible I saw
If you
that.
agreed with me.
Objection.
She clearly thought her arrogance would shake the attorneys, but the lawyer cut through it instantly, leaving her with nothing to stand on.
Would you be implicating the reputations of two officers?
If I was to lie, then yes.
And your entire job revolves around what you say on that witness stand. That's what you said, correct?
I'm still,
That's what you just said, Officer Dever, correct?
I still don't really understand the question.
You just said, all I'm asking you is what you just said. I wrote it down. You just said, my entire job revolves around what I say on the witness stand, correct?
Yes to that
Thank
question.
you. That's all I have.
One moment she spoke honestly, the next she retracted everything. It became clear as she couldn't be trusted.
I'm confused. When you spoke to those agents, you didn't implicate Chief Berkowitz and Mr. Higgins with doing anything criminal, did you?
No, they were friends. That's why Higgins had an office there.
You didn't implicate them ever suggesting they had tampered with evidence, did you?
No,
You never implicated them saying that they had framed anybody, did you?
no.
So when you talked to those agents, did you ever suggest that Mr. Higgins and Mr. Berkowitz did anything to touch or tamper with the defendant's Lexus at all?
No,
Never.
no.
Is there anybody you're protecting?
I have no one to protect.
Do you need to protect anybody?
No.
All right, Officer Dever, you're awesome.
Thank you, Your Honor.
All right, jurors will take our morning recess, 20 minutes.
She really showed just how corrupt they all are, and she was the one who started it. What an attitude. He pulled the trigger, and now he's paying the ultimate price.
The jury, having found you guilty of the offense of manslaughter and assessed this punishment.
12 plus years in prison for manslaughter, Dean was facing a murder charge, but the judge dropped a bombshell on the jury. They could consider a lesser charge. In Texas, manslaughter carried up to 20 years behind bars, and the outcome was anything but certain.
The jury has sent a note or given me notice that they have reached a verdict. Are both sides ready to receive the verdict?
State's ready, Your Honor. The defense is ready, Judge.
All right. Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Juror number one, it's my understanding the jury has reached a verdict. Is that correct?
Correct.
Is it a unanimous verdict?
Yes, Your Honor.
Okay. Go ahead, please, Deputy Nicholson. Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much. Jury, as we went through before, I'm going to call your juror number and ask you if this verdict is your individual verdict. Juror number one, is this your verdict?
Yes, Your Honor.
Juror number three, is this your verdict?
Yes, Your Honor.
Juror number four, is this your verdict?
Yes, Your Honor.
Juror number six, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 14, is this your verdict?
Yes, Your Honor.
Juror number 15, is this your verdict?
Yes, Your Honor.
Juror number 21, is this your verdict? Juror number 31, is this your verdict?
Yes, Your Honor.
Juror number 32, is this your verdict?
Yes, Your Honor.
Juror number 37, is this your verdict?
Yes, Your Honor.
Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much.
Dean claimed he saw the weapon aimed at him and acted in self-defense. But the real question is, did he even spot Jefferson's gun before pulling the trigger? His attorney hammered the point home, insisting that Dean had every right to protect himself.
Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law. You will receive credit for all the time that you have served in custody on this case from the date of your original arrest up until today, which would be the date of sentence. You have the right to appeal the jury's decision. You do so by giving written notice of appeal to the Second Court of Appeals here in Fort Worth within 30 days. I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Mr. Gill, Mr. Brissett, if y'all will remain on his case pending his decision whether he wishes to appeal, and if you'll furnish the information for the trial court certification of appeal before you leave here today, I would appreciate it. Is there an allocution? You may be seated. Thank you very much.
The officer was sentenced to more than 12 years in prison for manslaughter. But the reality didn't end here. A $3.5 million settlement was later awarded to the boy who watched his aunt get shot through the window of their own home. This next cop thought his badge would protect him from consequences. But today, the law didn't play favorites, and he paid the price.
That hardly mitigates the great damage you have done to this child, this family, and to society as a whole.
The former Jackson police officer faced the full weight of the law after a tragic incident involving his young daughter. What unfolded shocked the entire community.
Commendable, you have served as a Jackson police officer and detective for approximately 10 years prior to this crime. That hardly mitigates the great damage you have done to this child, this family, and to society as a whole.
Process made me question my purpose, question my faith. Because every hope, every dream revolved around her.
This is a very sad day, and we'll just keep on fighting the good fight for what's really right.
During the trial, shocking evidence revealed that Gray had a young daughter, though he maintained she had been sick. He was charged with capital murder, and messages and other evidence painted a disturbing picture of his attitude toward the child. Once a vice and narcotics detective, Gray is now serving a life sentence without parole. This next cop kept his badge, but lost it all in the court. Amy Vella called 911 after witnessing her boyfriend's fight with his father spiral out of control. What started as an argument quickly turned violent.
My boyfriend and his dad are drunk and they're fighting each other. My boyfriend's going around breaking and hitting a hammer and everything, but they're outside fighting. Can you guys please hurry? Load the gun. You loaded the gun. You loaded the gun? He loaded the gun. Okay.
Deputy Willis arrived on the scene, and in a shocking attempt to control the situation, he did something no one expected. When unarmed, Yvette approached the door. Deputy Willis fired without warning, striking her twice in the chest. Willis claimed he thought he was armed, but he was charged with murder and fired from the sheriff's department. He pled not guilty, and after a hung jury, the state prepared for a second trial, but this time without the jury.
Situation, there is plenty of blame to go around, and there are several people beyond Daniel Willis who shared this tragedy that eventually took the life of Yvette Smith. Mr. Daniel J. Willis, it is the verdict of this court that you are not guilty of the charges stated in the indictment. Anything from the state? No. Anything further from the defense? These matters are adjourned.
told y'all folks down here, man. Some
Willis kept his license but never returned to the department. He sued the county, the dispatcher, and the other officials, claiming poor training and that he wasn't told the gun was unloaded, but his case was dismissed. Meanwhile, the family filed a $5 million wrongful death lawsuit against the county and sheriff, which was eventually settled for $1.2 million. Well, that brings us to the end of this video. Today, we witnessed a shocking case where an officer thought the system had his back, only for it to end in tragedy right in the courtroom. Some people abuse their power, and this is a harsh reminder that no one is above the law. These actions must serve as a warning because justice can catch up in the most unexpected ways. If you agree with me, please consider showing your support by liking this video and also make sure to subscribe to stay informed about future cases like these.